Good morning and welcome to the webinar on workplace law under President-elect Donald Trump, What to Expect. I'm Sean Lyons, Executive Director of the South Dakota Retailers Association. Today's program will feature a presentation by Chris Hoyme of the employment law firm of Jackson Lewis, P.C. Jackson Lewis is a nationwide firm which deals with all facets of employment law entirely from the management aspect. Chris is a principal in the firm's Omaha, Nebraska office. He has successfully defended employers in over 40 federal and state courts, as well as before numerous federal and state administrative agencies. He is a member of the South Dakota Bar, and Jackson Lewis has offices in Rapid City. The Jackson Lewis firm was named the U.S. News National 2017 Law Firm of the Year in Employment Law Management category, and both the Rapid City and Omaha offices received recognition for excellence in the U.S. News Best Lawyers, Best Law Firms rankings. SDRA has a retainer agreement with Jackson Lewis that allows our members to contact the firm at no cost to get answers to general labor law questions. In addition, SDRA members are eligible for discounts on certain Jackson Lewis services, including developing employee handbooks and representation in lawsuits and unemployment insurance appeals. A few notes before we start the presentation. The phones of all attendees are muted, so we won't be hearing background noises. We'll have a question and answer period at the conclusion of the presentation. If you'd like to ask a question at any time, just go to the webinar panel on the side of your screen. You may need to click on the orange arrow to maximize the panel. Where it says type message here, type in your question, then click on send. At the conclusion of the presentation, I'll read the questions out loud and Chris will provide the answers. We'll now turn the presentation over to Chris Hoyme. Chris, good morning.
Good morning, Sean, and thank you. And Happy New Year to everyone attending today. I hope everybody's holidays were fulfilled and joyful, and now we can get ready for 2017. I would like to say in 2016, SDRA members set a record for using the retainer service that we provide, Jackson Lewis provides in conjunction with the association. Hopefully all of you will continue to take advantage of that retainer agreement, which allows you to receive free counsel on transactional issues that relate to labor and employment law. Simply give me a call at 402-391-1991 or email me. My email address is on these materials, and let us continue to serve the association, which has been a great, in my opinion, relationship over the years, and we look forward to a great 2017. As we discuss 2017, obviously we had a surprise in the election results in November. We have a president-elect who appears to be, in all likelihood, more conservative and employer-friendly moving forward, and today's presentation will discuss a variety of opportunities, if you will, for employers as we get ready for the Trump administration. And again, as you may have questions throughout the presentation, please follow Sean's direction and we will make every effort to answer them at the end of the presentation. And if you would rather simply email me or call me if you have questions that you forgot to ask or want to ask later, feel free to do that as well, and we'll make sure, as we do in all of these presentations, to get you practical answers that you can use to run your business. Okay, what we know is that on January 20th, the United States will have a new president, and both houses of Congress will be led by Republican majorities. We know that President-elect Donald Trump has stated an intention to reverse or modify many of the Obama administration's employee-friendly enforcement positions and rules. some of these changes may be delayed due to political back and forth, but we think we're going to see pretty significant initiatives in a variety of labor and employment areas, including trade, immigration, and of course the ACA or Obamacare. As we discuss these opportunities, I think it's very important to realize that our president-elect is not, as we have seen, a traditional Republican. He is not a traditional conservative, and he is not, by any stretch of the imagination, a traditional politician. So we need to make sure that we factor in, as many of our media experts learned, not only predicting the election, but as they try to predict what the Trump administration will do, that President-elect Trump is very capable of being inconsistent with what many experts anticipate he will do. So bottom line here is, as we discuss and speculate on what's going to happen, make sure you factor in the wild card nature of this president-elect, and keep a close eye on the news in Congress as all of these issues are discussed, because we can't anticipate Trump to act lockstep in traditional Republican beliefs. I think this was an example of this was seen yesterday when the House passed legislation attempting to modify the ethics investigative panel that is the watchdog for Congress, if you will. President-elect Trump sent out a tweet that basically said, "I don't understand why you're making this the first order of business," and within 6 hours that legislation was withdrawn. So keep your eye on the ball and understand that as we discuss these issues, there are many variables that may not fit traditional models. We're looking at providing a broad overview and educated and thoughtful speculation on what's going to happen. And similar to what the experts said in regard to the results of the election, and virtually all of them were wrong, make sure that we factor in, again, the uniqueness of President-elect Trump moving on these issues. But we do think we're going to see significant change in regard to enforcement and application of employer-related labor and employment laws implemented through the Department of Labor, the Equal Employment Opportunity Commission, OSHA, NLRB, and the like. And we look forward to seeing how all of that comes to pass. In regard to the EEOC, the Equal Employment Opportunity Commission, we know that the EEOC under President Obama has been very aggressive in terms of enforcing non-traditional areas of discrimination, retaliation, and harassment, as evidenced by the very aggressive enforcement of criminal background checks, systemic discrimination, and LGBT protections. We think it is thoughtfully very plausible that the EEOC will curtail many of these efforts under our newly elected President Trump, and we believe that not only will enforcement be curtailed, but the budget itself for the EEOC we think will be reduced. At this point, it's impossible to tell how much it will be reduced, but certainly the enforcement arm of the EEOC by most every commentator is believed to be going to be curtailed significantly. Interestingly, in October of 2016, less than a month before the election, the EEOC issued its updated Strategic Enforcement Plan, SEP if you will, for a 4-year period beginning in 2017, basically stating its commitment to a variety of priorities, including addressing inflexible leave policies such as attendance and leave policies that don't allow individualized accommodation, looking at complex employment relationship and structure, trying to protect against backlash discrimination against those who are Muslim, persons of Arab, Middle Eastern, or South Asian descent. So many of the somewhat maverick regulations and aggressive enforcement of those unique systemic discrimination priorities by the EEOC, we believe, will be significantly curtailed and reduced in terms of enforcement. We thoughtfully believe that these initiatives, for the great majority, will be not considered high priority by the Trump administration. LGBT, which, as we know, had been discussed in detail in the last 2 years in regard to transgender restrooms and the like, we don't think that is going to be nearly the focal priority point of the Trump administration as it was in the Obama administration. We think, for example, in most cases, those issues will be taken up by the states and not by the federal government through the EEOC. We think the initiative to expand the ADA, the Americans with Disabilities Act, to be significantly employee-friendly, as we have seen under the Obama administration, again, will be greatly and significantly curtailed in terms of application and enforcement. An example of this may be, I emphasize the word may, would be, for example, the EEOC regulation and application regarding attendance policies, where attendance policies that say if you miss so many days, regardless of the reason, you would face immediate termination, for example. The EEOC has said those are unlawful because they don't take into account the ADA's requirement that an individualized analysis be applied to each case. We think in that specific instance we may see some regression or lack of enforcement, which would allow such policies potentially to be enforceable that were not enforceable under the Obama administration. Also, the EEOC has significantly focused resources and enforcement application to retaliation cases. It's the #1 area of filed charges in the United States against employers. That is, employees claiming they were retaliated against for participating in protected activity, such as complaining about harassment, complaining about discrimination, complaining about OSHA violations and the like. Again, we think that is an area that is going to have less priority and less focus by the Trump administration through the EEOC. Likewise, in regard to the EEO pay data reporting, many of us know that final rules were issued in late September revising the EEO-1 report to include W-2 earnings and work hours for some employers. That rule was scheduled to become effective in March 2018, and we think it is very likely, as we monitor things, that the chances of that rule being implemented is probably decreased significantly and the reporting requirements under EEO-1 that's required by EEO-1 may not only be rescinded in regard to the W-2 earning and work hours requirement, but may even be further modified to make them more employer-friendly and sensitive to the time and resources necessary to fill them out. So that is an area to watch for those of you that are required to provide EEO-1 reports. Very significantly, in regard to the National Labor Relations Board, as we know, that's a 5-member board, typically composed of 2 members from each political party plus a 5th from the president's party. We know that because of the Democratic majority on that panel in the Obama administration, that the NLRB has been very aggressive in applying the National Labor Relations Act, specifically Section 3, that encompasses protected concerted activity, has been very aggressive, almost unique in American history, in applying Section 3 to non-union employers. And there has been case after case where non-union employers have had unfair labor practice complaints made against them by the government, indicating or prosecuting employers for violating Section 3. An example would be where employees were discussing, wages and conditions of employment, either orally or on social media. The employer found out about it, this non-union employer found out about it and took discipline against those employees for discussing wages and in many cases talking in derogatory terms about conditions of employment. And the government took the position that those employees, even in a non-union environment, were protected from discipline and termination, even if they derogatorily referenced their employer, because of their Section 7 rights. And we think, again, speculating, but we think thoughtfully speculating, that when the open seats on the board are filled by Trump appointees, that the National Labor Relations Board will go back to a much more employer-friendly board, especially in regard to non-union employers. We think it is fairly predictive that non-union employers will not face the rigorous enforcement from the board applying the National Labor Relations Act, specifically Section 7, to non-union employers in the aggressive way that we have seen in the Obama administration. We also think we're going to see reduced application and enforcement in regard to some very significant NLRA issues such as class action waivers, joint employment, quickie elections, definition of the bargaining unit, and the like. And for non-union employers, this may not be that significant, but for union employers or employers that are in the middle of getting an attempt, at least, to get organized by unions, this is very significant. We do think that this is an area, the aggressive nature of the National Labor Relations Board applying the National Labor Relations Act to non-union employers, is going to be much more employer-friendly. Okay? In regard to the Department of Labor, we are extremely optimistic that we're going to see much more employer-friendly application in regard to providing employers greater flexibility in using independent contractors, in allowing more usage of business franchises, which again will be considered very employer-friendly and welcome as we move forward. And we really see this through the nomination of the the nominee for the Department of Labor, who is Andrew Putster, who owns over 3,700 hearty restaurants, employs over 75,000 people. Mr. Putster has been very critical of a federal minimum wage. He's been very critical of the new overtime regulations that almost came to pass in November and December. We'll talk about that. He's been very critical of applying the ACA or Obamacare to small employers. He's been very critical of the fiduciary rule. Surprisingly, though, he's been very expansive towards the value of immigrants in terms of using them as employees and the value that they bring. So if and when, and we think Mr. Putster will ultimately be confirmed, but we really have a pro-employer nominee to head the Department of Labor, which will be very welcome. Now, in regard to the overtime law that almost became effective on December 1st, 2016, many of you may have attended various presentations or webinars, including those by me over the past year, where we basically said we think there is a high probability, if not certainty, that the new overtime law, which would raise the minimum threshold almost or more than double it to $47,000 for an individual to be classified as management and therefore exempt from overtime, we took the position that this was going to happen regardless of the election. As we know, in kind of a Hail Mary upset bid on December, right before it was supposed to be effective, a court in Texas enjoined the whole law, saying that it needed more information in regard to how it was implemented, and basically enjoined it until after the election in the Fifth Circuit Court of Appeals. Logistically, as we look at this issue, the briefing, both parties are appealing and are submitting briefs. Those briefs are not due to the Fifth Circuit Court of Appeals until the end of January. A decision will not be reached in all likelihood until late February or March. And we think it is highly probable that some type of modification of the new overtime law will be effected before that Fifth Circuit takes any action on the appeal. Well, what does that mean for you employers that have been watching this law, in many cases getting ready to apply the new law, determining how you are going to adjust your minimum salary to $47,000 to your management employees? Obviously, we have to watch it closely, but we think that it is highly likely that we'll see potentially a number of different options. One, we could see no change at all to existing law, and the current threshold of 23,000 plus could remain in place. Two, we could see a more grandfathered in approach to increasing the threshold. We could also see changes in regard to who this new law would apply to in regard to medium and small employers. Perhaps they would not apply it to employers with less than 50 employees or 100 employees. So we think we're going to see drastic change to what we thought was going to be law on December 1st, and we really don't have a good idea as to what those specific changes, if any, will be, but we are very optimistic that they will not be the changes, the drastic changes that were going to be put into place on December 1st. So we think that's good news. We are optimistic that Mr. Putster will be confirmed, And one of his first orders of business will have to be how he is going to interpret and apply the new overtime law in some form, because the briefing and the case in the Fifth Circuit will be coming down the pipe unless the appeal by the Department of Labor is withdrawn. So if you take anything out of today's presentation, it should be keep your eye closely on what, if anything, the Department of Labor does with the new overtime law. Somewhat interestingly, during the Obama administration, the DOL discontinued its long-standing practice of issuing opinion letters signed by the administrator. Basically, employers would request an opinion letter on a specific DOL issue and could generally rely on the opinion given to apply labor law in regard to the specific issue raised. That practice, in essence, was discontinued under the Obama administration, and we think, thoughtfully, based on what we've seen from Putster and, of course, President-elect Trump, that process of requesting, receiving, and relying on opinion letters may be restored. Okay, likewise, for federal contractors under the OFCCP, that agency has been very aggressive and liberal in enforcement in terms of applying what we consider to be anecdotal, unique areas of discrimination and retaliation and harassment. Without getting too much in the weeds, we think we're going to see a real pullback in regard to federal contractor employment-related regulations that we saw under the Obama administration. We're going to see a real pullback, we think, as well in applying the fiduciary rule in regard to ERISA. Again, not getting too far down in the weeds, but this could be a real benefit, especially to medium and large employers. We think the fiduciary rule in all likelihood is going to be significantly altered. Of course, that brings us to ACA and healthcare, the Affordable Care Act, and this is a very, very fluid situation, as we've seen in the last 3 days in regard to the Republicans who ran on repealing Obamacare. As Trump indicated continuously throughout the campaign, it does appear Democrats are going to identify that issue as a real political battlefield, if you will. And so we've gone from the political rhetoric to practically how is this going to occur, in what form, in what time frame, and what really are we looking at. We know today, for example, that President Obama is meeting with various Senate and congressional Democratic leaders to plot a strategy to push back hard in the media and through obstacle legislation, if you will, to not allow Obamacare to be significantly changed. President-elect Trump has recently tweeted, which apparently is the best way to communicate or understand his communications. He's indicated, and his spokesman Kellyanne Conway indicated yesterday on CNBC, that they do not anticipate significant changes in a short period of time. Kellyanne Conway indicated yesterday that it may be a number of years, and that in all likelihood, as I interpreted her remarks, we would be keeping parts of Obamacare, but such as pre-existing conditions, allowing children up to a certain age to stay under their parents' health care, but looking at other issues related to pricing and application to be repealed or at least revised under our congressional, as some interpret it, mandate by Republicans. So don't count your chickens. For those of you that thought Obamacare would be just bounced out immediately, it appears, again speculating, but it appears that it's going to be a drawn-out process that, in my opinion, in all likelihood will not be as dramatic and certainly not something that happens on the short term in regard to substantive repealing or significant revision to Obamacare. Again, that's my opinion. It could be altered by something that happens tomorrow, but I don't think we're going to see the drastic changes in Obamacare in short order that many folks anticipated based on the results of the election. President-elect Trump has also indicated, as most of us know, that significant tax reform will be coming down the pike. We know that he places a high priority on tax reform that would be more employer-friendly, more middle-class, individually friendly. His tweet yesterday when he was critical of the House action on the Ethics Committee, he said, why are we making that a priority when we have all of these other issues such as Obamacare and specifically referenced tax reform? So that's going to be an area that employers need to watch closely, because we think there will be definitely a tax decrease and benefit to employers. As to what form and how much, we'll have to wait and see. Which brings us to another hot button campaign issue, which was immigration. President-elect Trump, of course, referenced building a wall, having Mexico pay for it, indicating that, of course, our current immigration laws would be drastically not changed, but simply enforced, and the amount of resources that would go towards enforcement in enforcing current immigration laws would drastically increase. We think, of course, his comments regarding monitoring and reducing the amount of immigration from certain countries and regions such as Syria, Libya, and Iraq. We think we are going to see some type of reduction there. But remember, when the United States takes action limiting immigration from certain areas, we can anticipate certain retaliatory or balancing immigration laws in those corresponding countries, where our immigration or our rights to travel in those countries or those regions could also be greatly diminished, which could have some impact on business travel and employer-related business moving forward as well. So again, that's a fluid issue. I think we need to watch it closely. Another area to watch in regard to immigration are the issuance of H-1B visas. Many of us use H-1B employees. We think that that will be an area that is scrutinized by President-elect Trump, although he has indicated on a number of occasions that he would like to make the H-1B program more employer-friendly, less bureaucratic, and more responsive to the needs of employers. So that is information that may be grounds for optimism moving forward. Again, work visas. We think that this is an area that, again, we could see more flexibility and employer-friendly business immigration allowed than we have right now. Likewise, in regard to E-Verify, President-elect Trump has indicated on multiple occasions he would like to see E-Verify applied to all employers. That will be something to watch. We know employers may be incented and encouraged to adopt E-Verify, and again, an issue to keep our eye on. Likewise, we have the Obama initiatives, President Obama initiatives that provided deferred action, i.e. no enforcement for currently undocumented individuals under the Deferred Action for Childhood Arrivals, the DACA, Deferred Action for Parents of Americans, DAPA. We got about 750,000 DACA recipients who have been issued work authorization from the Obama administration. It will be interesting to see what President-elect Trump does with these DACA and DAPA recipients in regard to enforcement from a political perspective. It's one thing to say, you know, we're going to enforce our immigration laws, but from a political perspective, I think you legitimately have to wonder how many deportations are actually going to take place, how is this going to flesh out from a political perspective. So again, an area to watch. Certainly we think that we will see in regard to enforcement a significant amount of resources and application related to enforcement of our immigration laws. Our Attorney General designee, Jeff Sessions from Alabama, if he gets confirmed, and I know he is targeted by the Democrats to try to deny him confirmation, but if he gets confirmed, he is a very law and order enforcement-oriented Attorney General who we can expect to take significant action to enforce our immigration laws. Likewise, our Homeland Security designee, General John Kelly, who would also be working in conjunction with our Attorney General in regard to enforcement of immigration laws. General Kelly is a four-star retired general. He has been a border security hawk. He is classed with Obama on efforts to close Guantanamo Bay. He is considered a very intellectual and pragmatic person in regard to immigration, but I think it would be safe to say, based on his record of enforcement, that when joining with Jeff Sessions, the enforcement arm of the DOJ in regard to immigration will be significant. And I think it would be safe to say that dramatic change from the Obama administration is going to occur in regard to immigration law enforcement. One of the huge issues, at least from many people's perspectives, including mine, was the impact of the Supreme Court on the Supreme Court as to who won the election. Right now we have an open seat due to the passing of Judge Scalia, and the balance of power, if you will, between conservatives, moderates, and liberals really hangs in the balance in terms of 5-4 decisions in regard to very significant employment cases, constitutional cases, and the like. So we know that President-elect Trump will have as his first order, one of the first orders of business will be nominating a Supreme Court nominee. And in all likelihood, it will be a conservative. In all likelihood, it will swing the court back to a more conservative bent, certainly in line with the Scalia courts that we've seen in the past. And, of course, we have at least 2 other judges who are over the age of 80, I believe, who you have to anticipate may step down or not be able to serve further during a Trump administration, whether that is 4 years or 8 years. So clearly he may have the opportunity to nominate more than just the Judge Scalia replacement. He may have the opportunity to nominate 1 to 2 more justices after that, which is so significant in interpreting court opinion, legislation, and the like, and extremely important to how our labor and employment laws in regard to, for example, arbitration, EEO, Title VII, workers' comp, OSHA, and the like, having a court that is more moderate or even more conservative obviously would be greatly beneficial to most employers. Now, interestingly, President-elect Trump's victory was primarily swung through the Rust Belt states. As most of us know, about 80,000 votes determined who won the swing states of Wisconsin, Michigan, and Pennsylvania. But the total vote there that swung it from Secretary Clinton to President-elect Trump was about 80,000 votes. And obviously Trump made a significant connection to the Rust Belt working class. Part of that attractiveness was Trump's platform on a variety of issues, but one of them was surprisingly paid maternity leave. President-elect Trump is on record as indicating that he would like to see some type of paid or partially paid maternity leave. He would like to fund this by amending existing employment statutes where unemployment benefits basically would be used to fund the maternity leave. And this was definitely an issue that allowed Trump to kind of cross traditional Democratic voting blocks. So I think we're going to see not only some type of modification or changes in paid leave, but there may be other issues as well where we may see that as not necessarily employer friendly, but in terms of politics, very voter friendly, and President-elect Trump recognizing various voting blocks that in essence swung the election to him. I think an example of this uniqueness, if you will, is seen in the Trump's position in regard to employers keeping jobs in America as opposed to offshoring them to Mexico, Asia, and the like. And yesterday even, when Ford announced that it would not build a $1.6 billion plant in Mexico, but rather would save at least 700 jobs by enlarging a plant in the United States, we had this unique Democratic crossover of the United Auto Workers issuing a statement indicating they were, you know, they didn't go overboard and praise Trump, but they indicated they thought this was an excellent move and they welcomed it. So as employers, I think we have to factor in that there may be more examples of this where President-elect Trump does not fit the usual profile down the line of employer-friendly laws consistently. There may be exceptions. This isn't like Romney, for example, getting elected and we could just know exactly from points A through Z in all likelihood where he was going to go on employer related legislation and the like. So I didn't mean to editorialize, but I think that the uniqueness factor we need to be aware of and follow closely. During the campaign, also, President-elect Trump referenced tax deductions for child care and elder care, an expanded earned income tax credit as a child care rebate, a dependent care savings account to complement the existing dependent care flexible spending account. All of these things I think we need to watch, and although I think on larger issues we'll see employer-friendly legislation, there are areas like this where we may be somewhat surprised. On the employer-friendly side, we know that recently, especially in the last 2 years, the Obama administration has taken some very aggressive legislation, executive orders, and the like against the ability of employers to implement and enforce non-compete covenants. And we think this initiative will be, in essence, gutted by a Trump administration on a federal level. And again, we think the president-elect will move to allow states to dictate their own law in regard to non-compete covenants and the like. We think that states will be allowed to interpret their own laws in regard to minimum wage and overtime, paid sick leave, LBGT rights, criminal background checks, and all of that. And it really cuts both ways. We may go, oh great, the federal government is not going to be directing employers on all of those areas, minimum wage, criminal background checks, all of that. But we think that more liberal states, blue states, if you will take action to push back against the lack of federal enforcement and may pass much more aggressive state, county, and citywide laws in regard to these specific areas. So depending on where you live, and I think in South Dakota we can probably exhale knowing that we are in a fairly conservative state and we won't have the federal government, and under Obama a much more employee-friendly federal government, if you will, enforcing employee-friendly laws. We do think it's going to be left to the states, and we do think, depending on where you do business, you may have less restriction, less enforcement for employers, but in liberal states, cities, and counties, you may end up having more as a pushback to the surprising result in the election. Again, we've talked about non-competes. Summing it all up in a nutshell, I think that we are in for dramatic change. I think we may be surprised on some minor issues that the change wasn't what we expected. I think we're going to see a Supreme Court that is much more employer-friendly and more conservative. I think on immigration we are going to see much greater enforcement. I think on ACA Obamacare, I think we need to be braced for a much slower and less dramatic change than what many of us anticipated. But overall, I think it is fairly safe to say that from an employer's perspective, we are going to be very optimistic and welcome the change that we see under a Trump administration. So that's all I have for today. If people have any questions, I'd be happy to answer them. If you'd rather email me or call me, please do so. There is my somewhat menacing picture. Maybe I need to cheer that up a little bit for 2017, but there is my email address and phone number, and not only on topics related today, but anything related to labor and employment as part of your SDRA membership through the retainer, please take advantage of it. So thanks for attending. Have a great rest of the week and a great 2017. Thank you.
All right, Chris, thanks for a great presentation as always. And I would remind everyone, if you have a question, to go ahead and type it in on the screen there where we gave you indication. Again, the reminder is you may need to click on that orange arrow to maximize the panel, and where it says type message here, go ahead and type your question in and click on send. And we've got a few questions, Chris, and we'll let you pontificate on those. And obviously, it's a lot of speculation for all of us, both on the legal end as well as the political side. But let me go ahead and ask you a few of the questions that we've gotten submitted. If parts of Obamacare are repealed, how long would it take before the changes would go into effect?
Yeah, and that's a great question. It's a question that I don't think a specific answer can be given, but I think from a political perspective, and this is how the Democrats are playing it, and it's a good question, is if you're going to change something, do you have a replacement? Because you cannot suddenly have people who were covered under Obamacare suddenly without any coverage or floor underneath them under a new plan. So I think that argument and concept is going to slow things down, because from a political perspective, you can't say, well, we changed it, we lowered the price, but 4 million people now don't have insurance that had it under Obamacare. I don't think that is viable politically, and that's where I think the long argument and gymnastics legislation is going to take place. So therefore, even if they do change, I think any change will be grandfathered in over a relatively long period, so that these changes can be implemented in a way that protects as many people as possible.
Next question, Chris, is many businesses in South Dakota use the H-2B visa program to hire workers, especially seasonal businesses. Would that program be in jeopardy with immigration reform?
Again, the disclaimer that there's a lot of wild card involved here. Based on what we've seen from the campaign and what we have seen from the people that he has nominated, we think that program will be left alone, and in all likelihood, a good chance that it may be strengthened in terms of making it more flexible and available to employers. So in regard to H-2B, we're very optimistic that it could become even more employer-friendly.
And the last question that I'm seeing right now, oh, I'm sorry, there are a couple more, excuse me. I missed part of the webinar, so you may have covered this, but what can we expect to see as far as raising the federal minimum wage?
I think it's safe to say that we probably won't see a rise in the federal minimum wage. The only wild card caveat to that is that based on the populist swing that Trump got, that in essence got him elected, I guess it's possible he could do something on a minor scale to show his appreciation for that voting bloc. But based on everything we've heard, especially looking at the comments and history of the DOL nominee, Puzder, it would be surprising to see the federal government increase the federal minimum wage.
Chris, the last question that I have at the moment, and if anybody has questions, please once again feel free to either email those in, or if you can do so on the screen to submit. Can you talk a little bit more about the changes we might see in terms of criminal background checks? And Chris, I'll expand on that question a little bit. We've talked in the past about ban the box type legislation, both at the federal and at the state level. Can you talk about that a little bit?
Yeah, that's an area that I think an educated, thoughtful prediction based on what President-elect Trump and Puzder have indicated, and also his his other nominees that would be applying the background check and who we anticipate to be the head of the EEOC, we think that it is likely that the federal driving of aggressive background check legislation and enforcement that we have seen is going to be drawn back perhaps significantly. The caveat to that is that in conservative, and it's going to go to the states. Instead of the federal government driving it, it's going to go to the states. So if you're in a conservative state, such as South Dakota, I think we can take a nice deep breath and go, we're not going to see dramatic federal or state implementation of restrictive background check laws that in many instances tie the hands of employers, as I and others have discussed to your membership over the years, in terms of who they can hire. If I don't want to hire somebody with a felony conviction, I think under the Trump administration, I'm going to be much more able to do that in all likelihood than I would be currently based on the EEOC application. If I live in a more liberal state, such as Minnesota, such as obviously California, New York, Illinois, I think the state action there could end up being more employee-friendly, more aggressive against employers. So it depends on where you are, where you do business, but I think it's going to go to the states, and if you're in a conservative state, that's a good thing.
Chris, there's been considerable talk about requiring paid family leave. Would they be likely to exempt smaller employers?
That's another really good question, and I think the speculative answer, but I think it's got a lot of basis in terms of what we've heard from the prospective Trump administration, is that we are going to be nuanced and sensitive to applying federal regulations and federal law to medium and small employers. I could see the opportunity to exempt small employers, whether you define that as 50 employees or 75 employees or less or 100 employees or less, but exempting small employers from many of these aggressive federal government-driven employment laws, which is a good thing. And I think you're going to see that in regard to the new overtime laws. I think it's probable that some change in the overtime laws and increasing the minimum threshold is going to occur in the next couple of years. I think it's also probable, again, the caveat, anything can happen, but I think it's probable that small employers could be exempted from those increases because they just don't have the available labor revenue to meet an increase. So I think you're going to see more of a realistic sensitivity to employers saying, look, for large employers, we think this is a legitimate expectation. For example, to raise the to raise the salary threshold. But for small employers, it just doesn't make sense from an economic perspective, and we're not going to require it. So I think I really am optimistic that we're going to see much more nuance, much more sensitivity to small and even medium employers than we saw in the cookie cutter one law applies to every level of employer that we saw under the Obama administration, in my opinion.
Chris, any other closing thoughts before we wrap things up?
No, I think it's like anything else. Keep your eye on the ball, monitor the news. I know the association does a great job of getting news out. We try to provide the association and all of our clients and friends updates. You know, monitor the SDRA website, monitor the Jackson Lewis website, because it's a fluid situation. It's kind of fun to watch, but we got to keep our eye on the ball, and we'll do our best to get information out quickly when changes are made.
Well, sometimes it's like having a root canal without anesthesia. I don't know that it's always fun, but it is a process. And I would just add to Chris's comments. Obviously, we're getting ready for the start of the 2017 South Dakota legislative session. And just like we're going to see in Washington, here in Pierre, there'll be a lot of new legislation that we anticipate. We have about a third of the legislature being brand new, and SGRA is already receiving several different proposals that will impact our members with regard to labor law. And so you can count on SGRA to be watching out for your interests, and pay close attention to our legislative bulletin that will be going out throughout the course of the session. I would also put in a plug that on Monday afternoon, January 9th, we'll have our annual meeting, which includes the legislative briefing. We'll be hearing from Governor Dennis Dugard, House Speaker Mark Mickelson, and Senate Minority Leader Billy Sutton, as well as a preview of bills that we're hearing about already. If you've not registered and are interested in attending, you can go to SGRA's website, that's www.sgra.org, and get registered to attend that meeting. Chris, thank you very much again for an excellent presentation. This webinar has been recorded, and a link to the recording will be emailed out to all of our attendees tomorrow. Also, a reminder that SGRA members can contact Chris and the Jackson Lewis Law Firm with basic employment law questions at no cost. For information on how to utilize that service, contact our office at 1-800-658-5545. Again, our number is 1-800-658-5545. Chris, thank you very much.
Thank you, Sean.
And we want to thank everyone for participating in today's program. Have a great day and a Happy New Year.